My name is Lynn Gibbs, and I moderate a Google discussion group of California statewide advocates who are focused on serious mental illness. And it's California Advocates for Treatment. And I want to welcome you all for being here today. I recognize some of you. The way this program came about is that several of us were on an AOT, Assisted Outpatient Treatment chat, hosted by the Treatment Advocacy Center. I see Amy Lutz is here. And during that conversation, we recognized that California has a different situation from a number of other states. And we also have unique challenges with our assisted outpatient treatment programs in California. And so it seemed worthwhile for us to have our own California AOT chat. I am really glad that we have two experts here today to guide us. Carol Stanchfield is from Turning Point, and she runs the Nevada County AOT program, which is generally regarded to be the gold standard for AOT programs in California. And their program, of course, has been in place a good many more years than those of us who currently have programs, or those who are about to have programs, hopefully, this summer. And our other speaker is Randall Hagar, who many of you know. Randall's been the guiding legislative light for a number of years on LPS and on AOT. And more recently, he's worked closely with now Senator Susan Eggman on the more recent legislation regarding Laura's Law, and some legislation that's also in the works now. So I just wanted to set kind of a ground rule where we'll hear from Carol and then Randall, and then open up most of the rest of the meeting for question and answers and discussion. And I'm going to ask that you either raise your hand to ask a question when we get into questions and answers, or enter your questions in the chat, and I can read from there. And to try to limit your question each time to 2 minutes or so that we all have a chance to ask questions, hopefully. So, is there anything I left out about? I just want to thank Lisa and Ed Bowman so much for hosting this.
Thank you.
They just stepped right up and said, yeah, we'll do it. And so that's great. Okay, so so Carol, would you like to take it from here?
Certainly, thank you. And I'm not sure if you'll be putting the notes on the screen or not, but
are you ready?
I'm ready. Yes, I will just say a little bit about who I am now. First, and that is that while I did help to start the program, participated in the development of AOT in Nevada County and the implementation of it, and did lead it, coordinate the treatment for many people over the first number of years. In the last 2 or 3 years, I have moved to a different position. So my position is the director of AOT and ACT for Turning Point Community Programs in Northern California. So that's what I do now, and part of that is looking at fidelity to the ACT model and to AOT. And so that's where I'm coming from, that it has been really a wonderful opportunity, a privilege to be part of the first AOT program in California in Nevada County. The program in Nevada County started in 2008, and so we've had quite a bit of outcome data that has supported the efficacy, certainly, of Laura's Law over these years. So I'm not sure how to advance the slides. Do I do that, Ed, or do you do that? Okay. So enough about me. So we can go on to the next slide. So just to set the context of Laura's Law in California, really, as in so many counties, it was implemented due to a tragedy. So that was the events that took place on January 10th of 2001, where a gentleman with severe and persistent mental illness went into the clinic in Nevada County, and he was untreated, and as a result of his need for treatment and his symptoms, 3 people died, including Laura Wilcox and Pearlie Mae Feldman and Michael Markle. So that in 2008 was clearly still a trauma that we experienced here in starting intensive outpatient community-based treatment. Part of a presentation I did more recently, I titled Beyond Stigma. And the reason for that is because we, while initially we started programs here, we saw a very different culture and a great deal of stigma associated with people with mental illness, period. Not to mention those with severe and chronic illness. But what I discovered in my experience of working with individuals and their families, their parents, their loved ones, is that AOT really helps to move people beyond the stigma into lives that are more fulfilling, satisfying, quality of life that many families didn't think that they would ever see with their loved ones. So I felt that in the campaign for stomping out stigma, I think that a significant impact was made through Laura's Law and in Nevada County and in other counties as well where it's been implemented. So the next slide really are just the names: assisted outpatient treatment. So promoting hope. So this slide I think is really important because the way we move beyond stigma is to promote hope and to empower recovery, which happens really throughout the process. It happens in court, it happens in the community, it happens in treatment. And I think that level of empowerment really helps to move people beyond that experience of stigma. The next slide, this is not, as you said, Lynn, this isn't going to be an introduction to AOT. This is going to be more of an overview and an opportunity for other people to talk about and ask questions. So I don't want to spend a lot of time on that. But Ed, the next slide is the criteria, the one beyond this. Yes. So we all know that it's the criteria can span over a couple of pages, and when we submit this information to the court, it could be 3 or 4 pages because we're expanding on why this person meets criteria. we want to make it perfectly clear that this person is struggling. They are desperate in many ways. Families are desperate for help, and we want to make sure that there is no question once we get to court, if somebody meets criteria, that it is clear based on the criteria set in the law. So this is just kind of a quick overview of what the criteria is. The next slide, it's an important one because I think that in the continuum of care, it shows where AOT is versus 5150 or grave disability. So what we say is that the element of dangerousness is lower, it's a lower threshold than a 5150 or 5350. It's not an imminent threat and it's not grave disability. Even though many, many times we help people to get to the hospital and we know they meet criteria, but time and again, as many parents know, their loved ones are not kept. They're sent home, they're sent back to the streets, and they miss the threshold, however that's defined in the county. So we know that the element of dangerousness is lower many times than the threshold of a 5150. And yet people fall through those cracks. We don't want them to, because there's too much suffering that happens there. So one of the arguments is that, you know, oh, we already have LPS, we already have 5150, we don't need AOT, we don't need a Laura's Law because we have these other things. Well, voluntary services are not an alternative to AOT. AOT requires that voluntary services have already been offered and refused. Over and over again, they've been refused. So here we have to make a decision about, you know, do we go forward? Yes, when the negative outcomes are so severe that risk of restricted placement is imminent. So I think we're through with this one. I just wanted to mention that because I think that's an important transitional period of time that we need to capture. The AOT team director, this was my job. One of the hats I wore was the AOT team director, and these are the list of things that person is responsible for doing: investigating, scheduling the interventions, offering the services, doing the exam, evaluating the candidate for meeting criteria, developing the treatment plan with the person, or in court, we negotiate a treatment plan and then prepare the documents for the petition, and also prepare the status reports for follow-up status hearings. So you can go on to the next slide. This reminder that the court is a civil court. It's a closed court. The other thing to know is that a settlement agreement or a court order have the same weight. Sometimes people say, oh yes, I'll do this, and other people say, no, I'm never going to do this. This doesn't apply to me. And then we have a contested hearing and we move forward. But the outcome generally, I think, in all of the individuals that we've supported in Nevada County, at least, there's only been one that has not resulted in a settlement or a court order. Clients are represented by counsel, and the process, again, the treatment empowers, the court intervention empowers people to make choices to improve overall health. And I think that's, you know, once you've experienced the steps of empowerment and the choices that can that are start to be considered immediately with that person. I think that helps to motivate, these little steps of engagement that lead to recovery. So then the next one is medication. It may be part of the court order, individualized plan. Medications are not forced. They're never forced in an outpatient setting, but they can be court ordered. The treatment plan can say something like, you'll need to see the doctor at least once a month and follow the doctor's recommendations. So initially that doesn't always happen, but eventually it almost always happens. So almost all participants eventually take medication and are empowered to do so. So these are just, some of the data that I pulled together in January for something else, but in the years since 2008, in July of 2008, we had our first court order, 161 referrals. Those are unduplicated. That means we've had more than 161 referrals because we have probably a dozen people that have been referred more than once. So hopefully that makes sense. We have about 13 per year in Nevada County. Total petitions have been 86, but not every petition results in a court order. The court orders or settlements have equaled 70. So 70 since 2008. It's not so many, but it makes a big difference to the lives of those individuals and to their families. We've had 16 AOT hospital orders, which is another motivation. When people say there are no teeth, there are some teeth, and we can talk about what motivates people to engage a little bit more. That's a whole other training, though. So we've had an average of 5.8 people per year that have been on an AOT order or settlement. And so between 5 and 6 people per year benefit from AOT Court and AOT Act team services and supports. So it's not a lot of people, but it's a lot of people that otherwise are untreated, suffering, and with those kinds of negative outcomes that lead to incarcerations, hospitalizations, emergency contacts, and put them at risk of somebody getting hurt or becoming more gravely disabled. We know that when people are untreated and they are gravely disabled, sometimes they do not recompensate very, very well or very quickly. We've seen that over and over again. So we can go on to the next one. There are a number of essential components, I think, that I've experienced over the years that are really important. And I think one of the things that some of us agree on is treatment fidelity. Treatment fidelity promotes client recovery, and that's proven. It's proven in the outcomes. You look at FSPs or ACT teams that are not operating in fidelity, you see a compromise in the intensity of services and resources that are otherwise available to them. And so I think that treatment fidelity is important. The other thing about AOT in particular is the level of monitoring. That level of monitoring helps to create some scaffolding, a safety net, if you will. So that, as we see somebody maybe every day of the week, depending on if they have medication, if they have medication outreach. We have a lot of contact with clients and have a lot of ability to check in and be with them and support, different activities, essential needs that they have, and so on. So that kind of monitoring, along with the court monitoring, really strengthens and reinforces the ability to quickly make adjustments to the treatment, step in and support in a way that can support stabilization and prevent some emergencies. So the other part is empowerment, and I say this because we have seen this so much. I mean, being able to provide choices through the process promotes hope, and it empowers people to make a decision. Maybe they don't want to do this, but they're willing to do that. So, okay, we go with what people are willing to do. That's where we start. It empowers choice, and it helps to lead to recovery. So we could go on to the next one. I think we're just about done. We know that AOT fills a gap in treatment continuum, and it is an important model in our response to people who need help and they have no awareness of that need. People with anosognosia, and I would just say as a caveat, I didn't know what anosognosia was when I first started, but I said to somebody, it seems like everybody that's being referred to us has no insight into their illness. And somebody said to me, oh, that's called this. So I thought, what a coincidence. Everybody's kind of being referred, and they don't see that there's something missing. So I think it's, that's been very clear to me that that's a deficit that we need to help to support. It's not a panacea, but it does support the possibility of engaging some in treatment that would not otherwise be possible. And that's true. I mean, you can, and I did say kind of to somebody not long ago with the argument that, well, we already have these voluntary, we'd rather see people volunteer. And I'm thinking about people I've worked with, and I said, and excuse me for saying this, but hell will freeze over before these people volunteer for services. It's just not going to happen. And so then what do we do? What do we do? Just say, oh, well, they don't want to? While they suffer and things happen. People die from that kind of neglect or response. And we know that AOT saves lives and protects civil liberties. Due process happens throughout AOT, and I think it is alive and well in this process. And it is possible to create a recovery-based AOT program within the context of ACT, even an FSP probably, but still I wouldn't want to see 25 people on a caseload in an FSP trying to do something like this. So I think there might be one or two more, and then I'll stop. There's just a couple more thoughts I wanted to share, and one is that AOT is sorely underutilized. I'd say in many, if not most counties in California where it's been implemented. We need ongoing trainings. We need refreshers. There should be, we should have some type of protocol that is more standardized around California for those counties that are implementing this, where there are timelines for trainings and training reviews and a dialogue around what is working and what is not. AOT is sometimes used as a transitional tool from conservatorship status, and that has started happening more and more in our county, but I know that in many states it is the primary way it's used, and in many counties in California it is also being implemented in that way, and I think that that's a perfect use of it in those transitions. And there is little hope for many people with untreated severe mental illness without AOT or some similar level of robust intervention in order to support the need. And the last slide is the next one. I just wanted to say a little bit about discrimination, because a number of times more recently I've heard this as being something that, you know, people talk about racism and then start talking about discrimination and how, well, they don't want to do AOT because it discriminates against certain populations. And I would just say that people who meet criteria for AOT are already underserved and are often those who suffer with the additional self stigma or social stigma that severe mental illness reflects. Severe psychiatric disabilities is a condition that is experienced by all families of all races, ethnicities, and socioeconomic classes. It is unwarranted, in my opinion, and this is my opinion because I have some, you know, I've thought about this. It is not, discrimination should not be used as an excuse for not providing needed treatment to those in desperate need of help. The other part of this is misinformation, which is in abundant supply. Misinformation promotes fear and becomes a barrier to helping those with the greatest need. So I would just I would say that, you know, as I have more thoughts, I write them down and hopefully they resonate with someone. And I just have one more thought. It's the next slide, and that I looked over on my desk yesterday and I before sending this, and I saw this little card that says each mind matters, and that is without exception, except in some places they make exceptions. Each mind matters unless it's somebody who will not volunteer for compassionate care that our loved ones should all be able to experience and appreciate. No one understands this message as well as parents and loved ones of those with untreated SMI. You advocate tirelessly for change, continuing to hold hope for the possibility that meaningful help and compassionate care will come. We will all continue to do our part and hold hope for the system transformation that is possible. And I speak, I say that so sincerely and appreciating that likely everyone on this call feels very passionate about this and it has worked tirelessly and sometimes discouraged but always with that drive to move forward. So that's all I got. So
Thank you. Thank you so much, Carol.
Oh, you're very welcome. I look forward to your thoughts.
It's so good to be able to learn from you. It's clear just how much experience you have with this. So thank you. I think and I know there are several questions in the chat, but I think we'll hold questions until after Randall's presentation. And I need to say that I'm glad this is recorded, because halfway through your presentation, Carol, my computer just suddenly got this loud buzz and died. And I had to power it back down, and luckily it came up again. So I don't want to frighten anyone, least of all me, but I'm assuming it's not going to happen again. But if it does, you carry on until I can get back. That's all I
We'll
can
be
say.
here.
Hopefully
We'll,
we'll be
we'll
fine.
wait for you.
Yeah. Okay.
Thank
Thank
you.
you so much. Oh, and one thing I forgot to say is that this is not a by invitation only meeting. So when we do get into the discussion phase, you can't, please don't assume that anything you say is confidential, because this is a public meeting, and anyone, can join. And we did distribute the link before the meeting, not very widely, but we also invited people to ask other people who might want to come. So thank you. Randall, are you ready?
I am ready. And at following Carol, I'd be happy to do that 100% of the time when I do a presentation. She makes it so much easier. So thank you, Carol, for your presentation. I'm prepared to talk about a number of things, but I think what's really important here is I look back on the history of what we've done in California, and I'm always looking for ways to do better. So when we had a bill last year, that was what it was about. We have another bill this year, that was what it is about. But as I listen to advocates from around the state, it's clear to me that counties are not making full use of the power inherent in the law and the treatment that the law facilitates. And I think Carol gave you a really, really good description of the things that are so important that a treatment program do in order for it to really, really work, and it really can work. This can be, a gold standard in every community, but the fact is that it's not. And so what I wanted to at least start off with was talking about some things that I think weaken implementation. And so what doesn't work, and I've seen this directly in even in the process of adoption of the Laura's Law or AOT program in a county, where there will be a statement or some direction to the county that says basically prioritize voluntary engagement, work, the individuals who would otherwise qualify for your program, but work them to get them to engage voluntarily. And so you get a directive from the Board of Supervisors, or you have a feeling on the part of the mental health director that this is a tool to use voluntarily. And that's as far as it goes, that's great, because we always offer services. You always start out with the presumption that there's no need to use the mechanisms of a court or the law if a person will accept, services voluntarily. But as Carol said, and said very clearly, there's just some people out there that's not going to work for. So sometimes you get direction right up front to the treatment teams that tell them how they need to operate, especially in this really critical stage of engagement, which is counterproductive. So if one of the counties I'm thinking of, after their first year, they had 5 people enrolled in the court supervised program. And this is a county that has a huge issue that Laura's Law could be providing a much larger role in taking people off the streets who've been there for years without treatment, who are obviously suffering, who are getting into trouble, who are, as Carol said, having all kinds of bad outcomes, don't understand their illness, and even in some cases dying because of that. So this is one of the things I think we need to work on to strengthen the implementation. There is a reluctance I've seen in some counties to actually engage the full processes of the court. And, this is a treatment model that, as much as we love assertive community treatment, as much as we might love full service partnership programs, it doesn't really work for the people that it can work best for, who can't take advantage of other programs unless you involve the court. So it is counterproductive not to involve the court, not to, to go into it thinking we're not going to have many petitions to the court. We'll use this mechanism, and maybe it's sort of the idea that there could be a court process to try to get people to leverage them into the program. That is not taking advantage of the full power of the court. The black robe effect is very real. And we have some wonderful judges, and Carol, I know, has Judge Anderson in Nevada County, and there's no one who does it better. I mean, judges are guys in courtrooms. There's bailiffs with badges. They sit up on the dais. You're not allowed to approach the bench. There's this whole dignity of the law that is so evident in every single symbol in a courtroom, that all kind of escalates together in helping people feel like there is a force that's there to help them. And if it's compassionate, and if the treatment works, then they really benefit. But not to involve the court is to kind of take a three-legged stool and cut one leg out from under it. So you got to be prepared in a county to use the court. And again, I think the law is there to be used. It's part of the model to use the court. It's part of the model to use some of the options that you have in the court. Carol referenced the contested hearing, and that is, at the end of the day, that's where the court can actually say, okay, I hear you don't want to do this. Evidence has been given to me that says that you would benefit from an AOT order, but I want to hear your side of it. I know you're not wanting to go there, so tell me about that. And the court engages in that process. But at the end of the day, the court says, okay, well, I find the evidence is that you meet the criteria for the program. I think you would benefit from the program. I doubt whether you could be safe in the community without the program, and I'm going to order a treatment plan that's been presented, which you've had full, opportunity to help give input to. And if you don't have that, even for the contested hearing, you're just not using the full potential of the law. And then there's the voluntary settlement orders. I mean, there is a reluctance on the part of some counties to engage the courts, to the extent that they don't even want to have the court sign off on a voluntary settlement. I mean, this is an agreement that you make as the client or consumer with your treatment team, and the court's there kind of watching in the background. You don't need to go to court. You don't need, it's not, you're not really contesting anything. There's not evidence and then counter evidence and then people to testify, and then, the court saying, and, weighing in the balance, I find, make a formal finding and all that sort of, the trappings of the court. But there is a voluntary settlement order, and, that's underutilized. And then the thing that, and I'm so glad that Carol and I have been thinking along the same lines. I think treatment fidelity is huge. If you get a treatment team and they come out to an AOT ordered client, and they show up and they say, well, I noticed you're in bed today. You're not really it doesn't feel like you really want to engage with me. Why don't I come back and see you tomorrow? And that's fine. Except there's not, if that goes on day after day after day after day, I mean, the effort that you're putting into engagement from the treatment team side is very minimal. And if they're not doing it 5 days a week, 7 days a week, they're doing it 3 days a week, 2 days a week, the service intensity has just jumped off a cliff. And that's not good you know, for the client. And it's not the way the program was intended to be implemented. So, you know, this is wraparound carrots, whatever it takes. When we wrote the original law, we said no more than 10 clients per member of the service team. We really want intensive services here. And instead, what happened in a couple of counties is that they had to rewrite their contracts with their service providers because there was so little engagement going on that it was kind of like, and you expect this to work? It doesn't. So these are some of the common shortfalls, you know, failings that I've observed in, you know, as a very, very interested observer in this process, where, you know, you just can't escape the judgment that if you could just tweak it and go a little bit more towards the actual model and have more fidelity with the model, that your clients would be not only getting better, they'd be graduating and moving out into the world. And they would have their lives back. They would be on some sort of reasonable path towards, you know, a recovered state, whatever that means for them. And they would owe it all to the program, but we're falling short, folks. That's one of my messages. So I think you could take that document down. That's something that, you know, we'd be happy to distribute in case you want to use it as a checklist. But, you know, the other thing I will say is that there is a county process going on now, and it was required by our legislation last year, and that was AB 1976. And all counties are basically considered to be implementing this unless they opt out, and they have to go through a public process. And that is going on, I know, in Santa Clara, in Sacramento, and many other counties around the state because of AB 1976. Just to really quickly review that, it did provide an opt-out. It made the law permanent. It allowed judges to make referrals. It allows multiple counties to collaborate and cooperate in the formation of a single program. And it really does provide, you know, an opportunity for much more robust engagement with the community of people in a county about, you know, what most people are probably aware of, which is a very visible evidence of people who have not got treatment on board, and they're very out there in public, and they're putting themselves at risk. They're certainly a large part of the homeless population. They may be being arrested, all those different things, but those happen in a very, very public place. So communities should have a chance to weigh in on that. And that's what we tried to design AB 1976 to do, which is to further community dialogue, to have conversations, to have people, to have a chance to talk about the problems that they see in their community, maybe in their family or with their loved one, but certainly engender that dialogue. So I think I'll stop now. We do have a new bill for this year, and I'd be happy to talk about that if anybody has questions, but I'd like to reserve the rest of the time for questions of me or maybe Carol, and we'll take it from there.
Okay, thank you so much. We do have several questions in the chat, and I think I'll read them first and then open it up to you all asking questions. This first one is from Denise Piper. For some of the smaller counties that have less than 20,000 residents, is it feasible to have a program that will benefit just 1 to 2 people? I would say yes, but what is the argument to support this?
I'm going to let Carol take a first whack at that. Nevada County is small, but it's not that small. I think Nevada County has 50,000 people.
I think it's feasible if there is in place a treatment option that could be adjusted to meet the needs of two highly intensive individuals. You know, my feeling is if there's a will, there's a way. And I've been to lots of small counties and by invitation to kind of talk about some of this, as well as larger counties. Los Angeles County came up here years ago. I think Randall was a part of that meeting. And I think when you start to imagine something, you confront restriction, you also have an opportunity to innovate and create. And I think you look at the resources you have, you try to adjust them as best you can, and then individualize the treatment and the path forward. That, you know, I think that takes a real collaborative effort. You would need the courts, one judge on board, and other people that are like-minded in terms of, yes, this person is not going to get well unless we can take this alternate path, supporting them to recovery. So I would say yes, it would be worth it, and I would say that's a good example of blending one or two counties together. As when I was in Amador County, for example, I thought about this, and I thought, gee, you know, why would a county that's smaller do this? But I could see it happening if it was happening in a kind of a mutual, creating a you know, a partnership with another county. I think it's possible.
Thank you. Can you talk about the importance of judicial buy-in?
Well, every county should be so lucky to have a Judge Anderson. I think having the right judge is critical. You know, if you could imagine, you know, and how this would happen, I don't know, but just by way of contrast, a judge that is not treatment friendly, particularly, or judges that themselves don't want to use the full extent of the law and act as barriers, you know, stand between the client and treatment. I mean, that would be a worst possible case scenario. So I think my experiences around the state is that there's often one judge who's willing to do this, and I think it's up to someone locally to figure out who that person is. You know, these days, judges who have sat on the bench for 20 years have really had their fill of people with mental illness appearing before them. So they may be in civil proceedings, they may be in criminal proceedings, but the judges know them well. And the judges, by and large, don't feel equipped in those more traditional settings to you know, to deal adequately with the issues. They don't feel like they have the tools. So amongst that group of judges, there should be someone who says, you know, if I can help provide an alternative, I will. So it's really important to find that person.
I just had a thought. We need traveling judges that just do this, that they know it. It's their expertise. And I think it's, you know, that might be a creative, out of the box way of making it happen.
So next question, the biggest objection I hear in Santa Clara County is that AOT will use so many resources and cost so much money, but benefit only a few. How would you respond to that?
I'd be happy to tackle that. We started out with 90 clients here, 90 in our ACT teams. So we had forensic and we had non-forensic clients. We blended everybody together. There aren't that many. You start out with a assertive community treatment, and then you blend them into an ACT team. Not everybody, for example, we have people in mental health court. Nobody's complaining about mental health court. That's a whole other specialty court, right? And it's a criminal court. There are far fewer people that would be referred under AOT. It's the same cost. It's the same cost. It's costs less than mental health court of how extended a lot of those interventions are. I mean, there's generally in counties, they have a timeline of a year or two where the person needs to graduate. I think if you look at it in terms of normalizing it, and this is what I did when our first clients came to us, I said, let's not think about it as being, we're going to go to court. Let's think about it as trying to engage this person in our ACT services. And in most cases, that worked. We engaged in a way that we met people where they were at. We were able to do it based on a relationship and mutual respect, and just providing the type of I don't know, compassionate care that people felt comfortable in then agreeing, oh yeah, that, I didn't want this, but I like coming here once in a while. And we, trying to engage somebody over time, and not be in a hurry to, run to court. But I do think that sometimes there is that normalcy. You want to just say, well, let's try this first. And if that doesn't work, then we say, yeah, we'll be moving forward with this AOT. But it's folded into our system here. It's not like, oh, those people are over there and those are over there. In visiting Kern County, we helped them kind of restart their program. And when we went down there, they had two separate, they had a forensic side and they had an ACT side. They both ACT services, but one was AOT court and mental health court folks, and the other side were people that were non-forensic. And we didn't say, you need to change that. We just said, here's how we do it. And it came back a couple of weeks later. They notified me that they had changed their approach. They were blending their programs so that it makes for a more seamless delivery of services, and then you're able to make the best of the resources you have. Sometimes you don't have all the resources you need, but you identify within your resources, what you can share, and you increase your capacity for treatment.
Let me just tag on to that. I think that was an excellent answer, but I'll give a much more political answer to the whole cost thing. And it keys off of something that Carol said, and Carol had said that for these, some of these people, I mean, as anosognosia, it's kind of like, that's the target audience, people who don't get that they're impaired, that they have a disability. And those people are just not going to engage in all the other services. So go through that menu of services that the county offers, and you're throwing good money after bad because they're failing, and money has been expended anyway. So if you're going to spend money, do it in a way that's effective. That would be one argument. The other argument would be otherwise, you're just saying you're not going to treat them, and you're consigning them to the oblivion of whatever happens to them on the streets, right? So you got to put up or shut up. Either you want to solve the problem or you don't. And if you want to solve the problem, there are costs involved, and you just need to bite the bullet and do it. So.
And I would just
Okay.
add to that, in terms of the costs, same costs. If you're serving somebody that's not an AOT client, or you are, they're the same cost in terms of the mental health issues. And Judge Anderson has always said this: we save so much money in terms of the civil court versus somebody that's involved in a criminal court. It goes on and on and on and on and on. And you know, not to mention the court charges and other associated expenses that are incurred for not treating folks.
Thank you. Let me find the next question. I just saw 10 more have come in. So we have a lot of questions, and I hope we'll get to most of them, or all of them. I just participated in a Sacramento County Mental Health, or City, CTY, Mental Health Commission meeting on AOT, and was stunned by the level of misunderstanding and misinformation among the speakers, even including members and staff of the commission. The commission ended up not taking a position on whether to opt out. Those in residents here, we need to stay on this. Voices are hostile because they don't understand.
Well, I would agree. I've heard about that meeting, and you know, those who know should share, because you know, disinformation doesn't do anybody any good. And I think we've seen too much of that in our national dialogue over, you know, a period of time. So we've always said the proper way to advocate is to educate, right? And I think knowing your basic facts and making sure they get out there and being able to support them in a public forum is obviously very important. But it's really concerning to me to watch a process like that happen and kind of wonder whether or not, you know, where is the county in this? Have they basically defaulted to the mental health board and its process? Is that their idea of public dialogue? Because I don't know that it is. What type of information did they provide in that process themselves? Is the county giving out packets of information? Did the board give out information ahead of time? Did you have proper notice and a chance to digest that information and respond to it? There's a lot of ways that the process can be weak. And I think that you know, have a gut instinct about that. You can address those kind of things based on your gut instinct, and bring it to people's attention that this is not what I expected. This is not the quality of community dialogue I want. We need to do better and be the voice that stands for correction of that kind of process.
Okay, the next question was for me, but I'm going to substitute one because I think it's even more important. Our AOT judge, we think, is very good. And she's the same person that does the LPS hearings in Santa Barbara County. But she's gotten very few cases because our behavioral health director is the gatekeeper for the referral to the court. And we feel really stymied because we know if more cases could get referred to the court, we would do so much better with our program. Do you have any thoughts on that? Is there any way to change the law? But I guess it has to be the behavioral health director who makes the referrals.
Yeah, by the statute does require that you know, somebody initiates a contact to the department and the department takes over. You know, and maybe that needs to be looked at. I just had an experience though with like a community initiated conservatorship in one of the counties. So if that can be done, maybe AOT could be initiated from the county as well. I would have to think about that, but I don't think it's a bad idea.
Mm-hmm. Thank you.
Well, I'd just like to clarify that just a bit. The counties refer to the county themselves if they're doing AOT internally, or to providers if they're contracted. But the director herself or himself shouldn't be acting as a gatekeeper. That's the person that's responsible to sign the petition. And up here, that is not the same person. I mean, that's a separate role. And I think counties can interpret it any number of ways, but I think it's important to make sure that there is a neutral party within the county system that sends those referrals on. It's the AOT director and team. It's their job to make sure that the person would meet criteria and to develop the documents for that petition. It is not their job to prove it. It's not the county's job to say no either. It is really up to the clinical process, and the judge would always defer to the clinical evaluation, and Judge Anderson has always done that because he has a different expertise, and we understand a bit about where he's coming from, of course, because I think that's the other piece we need to all know. As clinicians, you need to know your job, but you also need to know the law, and you need to know what the role is of the court. But I'm a little confused about how a director can be a gatekeeper. And that seems to be, something that probably needs a lot more time to discuss, and
yeah, it gives me food for thought, because I had thought that it was required, that that it was necessary, that role, but it could be somebody else. Thank you. How many, this is from Teresa Pasquini, how many counties are left to opt in or out? Do you know?
Well, I haven't heard of any county that's under this current process has opted in formally with a vote of the Board of Supervisors. So before this point in time, last year, we had 20 counties that opted in to do it, and we have 58 counties. We actually have, I think, 59 mental health jurisdictions in the state. So you can do the math as well as I can. 59 minus 20 is, and that's the number.
Thank you. This seems more a statement. The resistance to Laura's law by behavioral health systems often has more to do with beliefs than money considerations. Would you agree with that?
I think it's a combination of things, and I think that certainly I've encountered a number of counties. I know Randall has certainly as well, where there are beliefs that maybe unintentionally, but those beliefs are what promote the misinformation that's given to stakeholders or given to other people that are considering implementation. That's happened in many counties that I've worked with, and who've asked me to be part of the exploration. So when I read reports that some counties will put out, and they've talked to a few people, but maybe they've only talked to people that are like-minded, and that those are folks that are in opposition of AOT. And then that kind of strengthens all of that belief that this isn't good for us. So there's that. And then there is the argument that it's too expensive. You know, if you're only going to serve 6 people a year, then, but the other thing about that is it's not too expensive when it has such a positive impact on all the treatment that's provided in that county, whether it's AOT or FSP or just outpatient. The approach, the model itself has a positive impact on the continuum of care within the county. So, you know, it's a good investment.
All those other services that a county does and the accountability that should be there to do those services is improved by AOT. That was actually a finding from New York and Kendra's law in a formal study of their system there. So you guys can count on that.
Thank you. So here's a complex question. I've heard of counties that require a second court order when a Laura's Law client refuses meds and is deteriorating, when the statute allows the county to use clinical judgment to offer the client a choice between complying with treatment or a 3-day hospital evaluation. My understanding is offering that choice is what pushes most clients back into treatment before they deteriorate further into complete psychosis. This may be ACT, but it's not AOT. If it works, great, but these non-compliant programs will likely mess up statistics. Is this happening? Is it hurting success? And what can be done about it? And this is Mary Ann's question in case she needs to clarify it.
Well, there's a lot in that question. Let me take a quick shot at it and we'll see, you know, how far we get with it. You know, the whole idea there in the design of the law is that you do everything you can to encourage voluntary compliance with it, and an order for a treatment plan that would include medication. And that, you know, treatment teams are adept at that. Carol has, I think, fairly clearly, you know, set out how you get that done. But at the end of the day, you do have the option of telling the person that we've tried everything. You seem to be deteriorating. We can actually put you in the hospital. Do you really want to do that? And, you know, at that point, there's going to be consumers who are going, yeah, go ahead, make me. But more likely it's going to be, okay, you know, they'll go along, you know, and the treatment team will kind of smooth that over and make that work and say, you know, we think that that's probably a very solid decision on your part, and this is going to help. You. You're going to feel better, you know, whatever. So there is that kind of process. The LPS audit that was done actually points out best practices related to that. You know, the court having status hearings and having people back, the treatment team using graduated incentives, you know, whatever works. All right, you know, that's at the end of the day what has to happen. But so I don't know that I disagree that utilizing a range of options to get medication compliance, including even having to pull the trigger on getting them admitted to an inpatient unit, is a bad thing. I mean, those are all tools. At the end of the day, the goal is to get treatment on board. And if a person's not really happy with medication, those are tools that you can use to get them medication. So I don't know what's bad about that, how that would skew our statistics, how that makes the program worse. I see it more as a matter of having an array of available options to encourage medication.
Mm-hmm.
Mary Ann, did you want to follow up on that? You're muted.
Yeah, and I agree, and I'm not a treatment expert, but my understanding is that and this is rumor, and I'm just partly want to know if this is actually what's happening, but that some counties are basically refusing to even consider that ultimate tool of putting someone in the hospital for an eval without further order of court. And part of the dilemma there is it's a nice idea to be able to go back to court, but when someone is off their meds and they're deteriorating, you have a short timeline. And that is the reason why those orders are set up so that you can intervene early. Laura's Law is supposed to be early intervention. That's the whole concept. And so I would like to know if that's going on, and if so, is it working or is it not working, and is it going to mess up the statistical, if we're not really doing Laura's Law, if we're doing, I guess, some form of ACT instead, that troubles me because, I know from the Kendra's statistics and from Nevada County statistics that, and from the state I used to work in, that it works if you work it. So what's happening, I guess, is the first question. Is that going on? Are there counties that are simply refusing to use the tool?
Well, if I may, I would just say that I could speak for Nevada County and Placer County a bit as well. Nevada County has had 16 hospitalizations for evaluation. So under AOT, the judge has written an AOT hospitalization order that can be up to 72 hours. And generally, people sometimes meet the 5150 criteria, and we will ask for that hospital. If that's the most appropriate level of treatment somebody needs, absolutely. I'm not going to say let's not put that in our stats. I'm going to say if somebody's had more hospital days than they did, maybe the year before, I'm fine with that. If that's what has been needed to support that person in their recovery. But I think that one of the nice things about AOT is that Judge Anderson has used that tool, and we will say, we believe, and we don't have to wait for a hearing. We can just contact the team and say, this is our recommendation. This is what's going on. And we'd like to see this person get some assistance. They decided to stop taking their medication, and now they're, really high risk kind of things happening. Could we get the hospital order so we can do what you're saying is that proactive kind of prevention is to intervene. So they go over to the CSU or the emergency room just for another evaluation. Sometimes that's all it takes. They'll keep them 12 hours or so. And then, maybe the next day we go back to court so that we could kind of see how that happened. There's an intervention. It's not that we're promoting hospital days. What we're doing is an intervention that says, we really need to catch and provide that safety net before this person gets any worse. You see, so it's not like that happens very often, but we have had 16 orders from the AOT court for that kind of that catch area where somebody is at high level of risk and heading toward a 5150 or worse. So we want to make sure that we're filling that gap.
But you actually are going back for a second order rather than just using what's already in the first order?
Oh no, it's the first order.
Okay.
Under the first order, yeah, it's just here's the status now. So based on this, what does the team think we need to be doing? And usually, if it seems clear to the treatment team, we would get that okay from the judge, and he'd sign that order, and we go ahead and support the person to the hospital, or even our local law enforcement is very well trained in this area and partners really well with us. They know exactly what to do. So sometimes they support our folks too in just getting over to the CSU or the emergency room for that evaluation there. But that's through the AOT order. It's not a separate petition.
Thank you. Patricia has cited some interesting data in the chat if you'd all like to take a look at that. And then she follows it with a question, what is the consequence if someone is court mandated to take medication and they refuse?
I don't even know how to get to the chat. But,
yeah, I think the stats are largely unrelated to the question, so but it's interesting.
Let me take a quick stab at this because our new bill, which by the way is SB 507, it was introduced about a month ago. It starts to address this whole issue about the issue of medication. And so I'm not claiming it's a big solution for everybody in all places, but the whole issue of whether or not, I mean, technically, whether or not a court order does extend to medication, well, really it doesn't, because the statute says that involuntary medication can only be done within the construct of Welfare Institutions Code. I think it's 5238 or 33, something like that. In any case, that's what we call the Reese hearing, and that has to take place in an inpatient unit. We just don't do that in the community in California, but we're starting to think about ways that we can maybe be a little more expansive about how we think about medications and orders and community settings. And so in one piece of SB 507, we've actually asked for counties, when they're doing an evaluation, to also submit to the court an evaluation of whether the person has the capacity to refuse medication. And that would also be a kind of a flag to the court, to the treatment team, that here's a person for whom potentially, there's going to be a medication issue, if not now, then down the road. And so you start off with a professional judgment about their capacity to refuse, because that's the actual central finding of the judicial process in a Reese hearing. And we want to get that introduced as early as we can. We haven't prescribed a way to then move to the next step, but we see that as kind of a marker for special attention to the medication issue on the part of the court.
Thank you.
And I would say our experience with medication, although I would say every single person that has come into AOT has initially said, no, I'm not going to do that. Of the 86 or 87 petitions, we've had 70 orders. And of those 70, we've had 3 people that throughout the order did not take medication, but they did participate in the other treatment options. There are quite a few opportunities to engage. All of them saw the doctor, and that was an agreement that they made in court with Judge Anderson, that they would agree to see the doctor whether or not they agreed to take medication. And so it was offered. And what is interesting is that most people end up taking medication. And one young man, a couple of years ago, he graduated, and a couple weeks later, he came into the office and he knocked at the nurse's door and he said, I think I'm ready to try that medication that the doctor wanted me to try. So we plant the seeds, and we don't force anything, but we walk with people and take one step at a time and empower them to then make the decisions and according to their timeline and their pace. And I think that it generally works pretty well. But but we don't force medication. That's never been part of it, but it's still misinformation that's out there under this proposed model.
Thank you. This is a question for Randall from Lauren. Can you give insight on Senator Glazer's sponsorship with of SB 782 with step down from conservatorship to AOT?
Yeah, it's a great bill. It's absolutely congruent with what we're doing in SB 507. We've talked to the author and staff, and we think he's got a winner there. And you know, I think we hope that both of them go forward because they would both be really good tools to use.
Great. So we have a hint about what we need to advocate for in this session, huh? Question from Marty Fox. State of California Superior Court and Appellate Court judges are subject to election every 10 years, re-election within their assigned jurisdiction. It should, I don't know if it's a question or statement, it should come as no surprise that the political views of their communities shapes their decisions, including their AOT decisions. I think that's more a statement.
Well, you have a lot of power in your power to vote. That's what that comes down to. So use it wisely and let's.
Okay, the problem in Santa Clara County is the system being reluctant to change their approach to service. It cuts off there. Nava, are you still here?
It's a reluctance to change the way they do service delivery. And the other issue is that they've been practicing hospital avoidance for so long that it's very difficult for them to have a different kind of approach. So I think they see also the LPS, the AOT process as something they cannot put their arm fully around because it's not an LPS process. In a way, AOT is kind of separate from the LPS process. But the thing is really, I don't think it's an issue of money, but it's an issue about how case managers work. Right now, if you're in an FSP program and you become symptomatic, your case manager will not take you to the hospital. They will close the case and move on. If somebody does not want to engage, they will move on, right? And it all has to do with who's, you know, if this case went to the agency, is it open to the agency or open to the mental health system and all of those kind of bureaucratic type stuff. And so what's unique about AOT is that it binds the system to the consumer rather than the consumer to the system. And that's a different way of thinking that, you know, it's a lot of more hard work. And I think that's part of the resistance statewide to AOT. But you know what I see? I think it's gonna take us a few more years and you will have AOT is the law of the land because it's kind of creeping there. And you can see communities kind of waking up to it. And so, and you can see it from the audit report. So I think we're gonna get there in a few years. Yeah.
That's a great way to close, and we're about to close, but I'm gonna try to fit in one more question. I love this one. Is there a mechanism in AB 1976 that allows counties to opt out, then opt in, then opt back out, etc.?
Well, that's not something we anticipated happening. We figured once they opt in, you got them. Mostly the experience has been very positive. So if you can get a county to opt in, then ping-ponging back and forth is just, you know, be very unusual, I would think. Nothing would prevent it per se, but, you know, I think we're hoping that that doesn't get invoked.
Thank you. So we're at 2:29. There still are, I don't know, maybe just a few questions left. I wonder, Randall and Carol, would you be willing to entertain any questions afterward? And we could give you, I mean, you don't have to do it right away because I know you're really busy.
Well, I don't have to move on for a few minutes, so I could fit in a couple more. I don't know, you know.
Oh, okay. I was thinking of sending them to you via
Some
email.
flexibility. Okay. Yeah, either
Um,
way.
Okay. Ed, can we get back to these remaining questions after the session? I'm not really.
I'm happy to stay on.
Okay, I guess I meant, can we capture the questions so that I can put them in an email to Randall and Carol?
There's a way for me to save the chat. Yes.
Okay, great. And I put my email address in the chat. If anyone would like to contact me afterwards and would like, you know, the answers to the remaining questions. Or the link to the recording, I assume we'll probably make that, you know, available if that's okay with you guys, Carol and Randall.
No problem here.
Okay. Okay, well, I feel like we probably could have, I could have asked 3 or 4 more questions. So maybe we're going to have more questions at a future time for a future session. But I want to thank you all for joining.
Well,
Does
thank you
anyone
for
have
having
any
us, Lynn.
closing comments?
Thank you for having us, Lynn, and everybody for participating.
Thank you, Randall. Thank you, Carol.
Thank you. I appreciate your generosity in hosting this, Lisa and Ed and Lynn. It's really a privilege to have been invited to participate. I just admire so many people that's been on this call and in the group, and I just have great respect for you. Thank you so much again.
Thank you so much. And thank you, Amy, for joining us from Tech.